Good afternoon. This is Judge Alyssa Perez resuming the criminal docket for the 210th District Court for August 1st, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Go ahead and call it. Calling cause number 2023 0D06921, State of Texas versus Carlos Morales. May I have announcements, please?
Ada Winnery for the state of Texas, present ready, Your Honor.
And Lorena Nunez on behalf of Mr. Carlos Morales, Your Honor.
And we had some brief discussion off the record regarding Mr. Morales's appearance. Mr. Morales is in federal custody. Mr. Nunez, he is not present. We haven't had any logins. Can you tell me about what you did to see that he would be appearing today?
Of course, Your Honor. So I did speak, just a second, let me pull it up for you so I give the correct information. I not only spoke with my client, but I also spoke to his caseworker over there as well. We did get the Zoom link over to them. They did require me to go ahead and email it along with identification as well as my bar card. They said that they would have him on today at this time, Your Honor, at 2 o'clock Mountain Time. But it doesn't seem like they are on or connected to Zoom.
Yeah, okay. And with that, I'm not sure what the holdup is. If you need to make an inquiry, I don't mind giving you a minute to do that. But
no, and Your Honor, we've been set before on this motion that I filed. The last time my client was okay with me proceeding without him, simply because time is of the essence for him. Since he is in federal custody, his release date is coming up in mid-August, and if we don't get these resolved, then he will not be able to go to the halfway house.
Okay. Okay, then I understand that to mean you're waiving his appearance, so you may proceed.
Thank you, Your Honor. And I know the court probably did already look at my motion. The motion is pretty self-explanatory. It's in regards to the interstate agreement on detainers, and you see that in 18 USC. And the agreement applies to the transfers of prisoners for unrelated trials between two states when they're in federal custody and they have other cases pending.
And then yes, I may stop you real quick. Is the area code of 760? Yes. Is that's your okay? Whoever is phone number ending 400, if you could please turn on your camera and unmute. Let me see if I can ask them to unmute.
Hello?
Yes. Who is, can you identify yourself, please?
Morales Carlos.
Mr. Morales, do you have a video function that you can turn on?
If they're asking if I have a video function that I can turn on.
I'm not sure if that means...
The information that was given to my counselor was... It's not working to do the video.
Okay. If there's no video, that's fine. It appears that you're calling from a 760 number. That's consistent with where your client, that sounds like your client, Mr. Nunez.
No, I recognize his voice, Your Honor. I know Mr. Morales. He's been my client for some time.
Okay, Mr. Morales, for now, so just so the record reflects that defendant is now present, has just called in. We had just started your hearing, Mr. Morales, so your attorney was just beginning. For now, I'm going to mute you, okay?
Yes, ma'am. That's fine.
All right, sorry, Mr. Nunez, go ahead.
Thank you, Your Honor. And I'll just backtrack a little bit, and I'll be brief in what I already stated. The motion is based on the interstate agreement on detainers, and the agreement applies between states and individuals who are in federal custody in regards to transferring them upon the time that they are sentenced. If you look at Article 3 of the agreement, it permits prisoners to initiate a final disposition of their untried indictment, information, or complaints against them in another state, which we did do the moment that he did hire me with the previous prosecutor. I did inform her, I can't remember her name, but I believe she left the office and is not the county attorney's, that my client was in federal custody and he needed to be extradited to the U.S. upon his sentence in federal court. And it permits the state to go ahead and dismiss these cases if they take over 180 days. And that's what the law specifically states. And the agreement is applied to the Texas Code of Criminal Procedure via Article 51.14, which permits them to ask for their final disposition of their cases and for the state to have, or require the state to move on it. Because if they do not move within 180 days, it is seen as prejudicial, and they are suffering oppressive pretrial incarceration as well as anxiety and concerns regarding the outcome of their trials herein. And any further delay would cause the state and the defendant suffer in its ability to present their case and get their day in court, Your Honor. The state has significantly passed the 180 days. We've had multiple conversations. The state has not moved to go ahead and get my client here. And that is why we went ahead and filed these motions to dismiss. And if you look at State v. Cephas, a defendant who was convicted in that case for a federal offense was sent to federal prison. The defendant had to have them been transferred to the custody of the state through the interstate agreement on detainers, which also applies here in the state of Texas. The trial court chose to go ahead and dismiss that indictment simply because the state did exceed their 180 days, Your Honor. That is why we're here today, and that's why we are requesting that the court go ahead and dismiss the specific case. I know they don't have jurisdiction on the other case that's pending, but we do have a hearing set, I believe, on the 3rd in the jail magistrate to hear this exact same motion on the other case. And the reason that that one is at the jail magistrate is because he hasn't been booked on it. But he would have been booked if the state would have moved and went ahead and brought my client down from California, Your Honor, but they haven't made any attempt whatsoever to get him here. And he is suffering and is prejudicial simply because upon his release date, he won't be able to go to the halfway house simply because we haven't been able to move these cases because the state has not. And I'm not saying that the current prosecutor has not done it, but the state itself with prior prosecutors have not moved on it.
Okay. Miss Winery, and I'm just for my reference, the other case, I guess the one that it's a non-arrest is that cause number ending 2477, 2023-0D02477, a Mandel.
Yes, Your Honor.
Okay.
So-
Okay, go ahead, Miss Winery.
In reviewing the law for this case, there's something that the state would like to emphasize, and this applies when a detainer has been placed upon the defendant. The state has never placed a detainer upon this defendant, and as far as we've been able to research, there's no requirement that we do. So that's first. Had the state placed a detainer, let's assume that we had placed a detainer, there are certain things that must be done on part of the defendant in order for the state to even have the 180 days begin against them. So in Article 3, it says that on the basis of which a detainer has been lodged against the prisoner, the prisoner, shall be brought to trial within 180 days after he shall have cause to be delivered to the prosecuting officer and the appropriate court of the prosecuting officer's jurisdiction, written notice of the place of his imprisonment, and his request for a final disposition to be made of the indictment, information, or complaint. The request of the prisoner shall be accompanied by a certificate of appropriate official having custody of the prisoner, stating the term of commitment under which the prisoner is being held, the time already served, the time remaining to be served on the sentence, the amount of good time earned, the time of parole eligibility of the prisoner, and any decision of the state parole agency relating to the prisoner. B, the written notice and request for final disposition referred to in paragraph A hereof shall be given or sent by the prisoner to the warden, commissioner of corrections, or other official having custody of him, who shall promptly forward it together with a certificate to the appropriate prosecuting official and the court by registered or certified mail, return receipt requested. C, the warden, commissioner of corrections, or other official having custody of the prisoner shall promptly inform him of the source and contents of any detainer lodged against him, and shall also inform him of his right to make a request for final disposition of an indictment, information, or complaint on which the detainer is based. D, any request for final disposition made by a prisoner pursuant to paragraph A hereof shall operate as a request for final disposition of all untried indictments, informations, or complaints on the basis of which detainers have been lodged against the prisoner from the state to whose the prosecuting official the request for final disposition is specifically directed. The warden, commissioner of corrections, or other official having custody of the prisoner shall forthwith notify all appropriate prosecuting officers and courts in the several jurisdictions within the state to which the prisoner's request for final disposition is being sent of the proceeding being initiated by the prisoner. Any notification sent pursuant to this paragraph shall be accompanied by copies of the prisoner's written notice, request, and certificate. The state has not received anything from this defendant requesting any sort of final dispositions on his case. Furthermore, the state hasn't even placed a detainer upon the defendant for any of this to be initiated. But had we, all of the notice that has allegedly been provided, which we are assuming is this motion to dismiss, is not correct and would not trigger the 180 days in which the state would pursue the charges. However, the state would still have to have the defendant in custody for that 180 days to be triggered.
May I respond, Your Honor?
You may.
And Your Honor, it is my understanding based on conversations with my client and the prison over there, my understanding is that I was told that there was a detainer placed. That's the information I got, okay? That is one. My understanding is too that his previous attorney who did his federal work did send over a notice. That is what I was told as well to the previous prosecutor and the last one I had talked to, because she told me that they were gonna move on extraditing him. The next thing too is if the state is gonna go with that they never placed a detainer and just left them there, and that's why they're not obligated to go ahead and dismiss the case, they're simply shooting themselves in the foot, because in that case, then we have an issue of speedy trial. If they're not going to take responsibility and place the detainer and get them here on time, then they're simply saying that they don't care and they're not moving on it, which then creates another issue, which is a speedy trial issue then, Your Honor. Because at that point, they're supposed to at least move within 30 days of the arrest, and trial must begin within 70 days of the indictment or arraignment. So he's already been arraigned on this specific case. So the state is going to say that now they never placed a detainer on him, therefore they're not obligated to dismiss, and therefore the 180 days never kicked in. Then they're simply saying that they're violating his constitutional right to a speedy trial. And in that case, then the court should dismiss this case, Your Honor.
Your Honor, the state would disagree because at one point in time, the defendant was in custody on this cause number. He was released after 2 days of jail. And then for some reason, despite all of his bond restrictions, he ended up either in Doña Ana, New Mexico, or in California. So we had given him his constitutional rights by giving him a bond to which he was entitled. And he took that bond and, to our knowledge, absconded.
Well, no, the case was already pending, Your Honor, as well, which is why I believe, if I recall correctly, he was released in order to go ahead and handle that federal case, but he just ended up being sentenced on it. But I think the issues are pretty blatant, Your Honor. It's very obvious. I mean, if they're not going to dismiss based on the Shuttle Act or interstate agreement, then the court should dismiss based on a speedy trial, because they've known that he's been incarcerated in a federal court since October, when I was retained on this case and told the state that he was in custody over there, and they still did not move on it.
And Your Honor, I've checked the prosecutor files, I've checked the court files, I've checked everywhere that can be checked, and there is no information stating that there was ever a conversation with Mr. Nunez about this case. What I have seen was that there was an attorney prior to him that was replaced But the prior prosecutor, who was diligent in note-taking, never left any notes stating that she ever spoke with him about this case.
Okay. All right, anything else, Mr. Nunez?
No, Your Honor, just simply, I mean, as an officer of the court, we have our kind, we're obligated to let the court know exactly the conversations or to be truthful. I would just like to remind the court of that, Your Honor, and therefore we're still asking for that dismissal. If they're not going to do it under the interstate clause, then we ask the court to do it under the Speedy Trial Act.
Okay, that wasn't in the motion, right? The speedy trial, and I haven't seen a motion for speedy trial.
That is correct, Judge, but I'm simply just pointing it out simply because it became an issue at this point in time. We were not going to go that route, but I mean, now that it's been brought up and it's very obvious that is an issue. I mean, we can get the motion filed or amended right away, but I think it's still at the court's discretion. I mean, then at that point, then I would like to make an oral motion to dismiss based on speedy trial.
So looking at, I'm just looking at some of these entries here, in terms of what is actually stated in your motion, that request to dismiss is denied. It looks like he had a bond hearing back in 2022. Then he got a trial track in 2024, beginning January, which led up to monthly settings pretty much up until the June 11th final hearing plea deadline. I think on June 6th is when you had requested a hearing on your motion to dismiss, which was filed April 1st. So we went past that jury trial setting. We had the motion to dismiss set the following week on June 20th. I believe defense counsel passed on that hearing, and we ended up receiving another request to have it heard today.
Right, and that's because we wanted my client to be present, and I know we were close to it. I know the court already said it was denied based on that, but I mean, we have been trying to resolve it, Your Honor. I did speak to the prosecutor earlier today and beforehand as well. We're willing to still do a plea in absentia if they're willing to dismiss the possession of a firearm, dismiss that one, and we'll plead to the demand delivery to 2 years if that's, if they're willing to extend that offer. That was our counter. Because if that's the case, we can have the plea in absentia done right away within the next 2 weeks, and that way my client can at least go to the halfway house. I mean, he's already time served. And I know the offer of 2 years was extended last time. That's why we also were trying to negotiate that, but we need the dismissal on the firearm case, and now he can't go.
So technically, you have that new, I don't even want to call it a new case. 2477 is not technically with me yet. That's why you're in the JMAG on all these other things. Sounds like you all have been talking about it. For my purposes on his 6921 case, I am going to give him a new trial track with something that is, there's just nothing that is super soon. December 6th is going to be his new trial setting with the final hearing plea deadline on December 3rd. Mr. Nunez, if these things are not resolvable, either with your counter or any other way, feel free to file anything you'd like to, that you want the court to hear, right? We'll get you settings leading up to the trial setting. Ms. Winery, had you considered that counter?
Your Honor, I had considered the counter. That's when I looked further into the case, because to my knowledge, the only case that I have, I guess, for lack of a better word, any sort of jurisdiction over is that case ending in 6921. When I looked further into it, I discovered the Mandel, which is being handled by the Border Prosecution Unit. So that kind of changed my ability to really do anything with that case in particular. I had a brief discussion with the chief of that unit about this case, and I told him that I would keep him updated. So when I speak to him this afternoon, I will let him know their counter and see if that is something that he can work with.
Mr. Nunez, just looking at the 2477 case, I do see your motion to dismiss is filed there. But there is no hearing yet in the jail magistrate.
I did get notice via email, Your Honor, on
Oh,
that.
you did? Okay.
But I did, and also just for the purposes of the record, Your Honor, can I get a ruling on my oral motion to dismiss based on speedy trial?
It's denied.
Will the court entertain a motion to reconsider based on speedy trial if I were to get it filed today and we could get a hearing next week?
Oh, for sure. If you want to file something, I mean, I know this is kind of, I'm not going to say on the fly, but absolutely. If you file something, ask for reconsideration, of course, I'll review it.
Thank you, Your Honor.
So in the jail magistrate, it looks like you were set for July 3rd. You filed it on the first, set for July 3rd, but that
Mhm.
was canceled and there's no subsequent hearing.
I think it was Mr. Bracken who did send me the notice. I'll double check on that, Your Honor, but I know I know I had talked to Mr. Chris Bracken and he had told me he was gonna squeeze us in, so I'll go ahead and get that from him.
Okay, sounds good. All right, give us the heads up, Mr. Nunez. If you file that, please send the copy to Ms. Hernandez so I can look at it.
Will do, Your Honor. Thank you.
Thank you for your time. Thank you, Mr. Morales. If you don't have anything else, each of you is excused.
Thank you, Your Honor.
Have a good day.
Hello, Ms. Caballero, are you there?
Before you continue.
Yes,
Mr.
I am. Thank
We're
you.
Still on YouTube.
Page 5, Ms. Moneri, Brian Chavez.